Now I'll grab the Bivens, which I think is pre-recorded, so that'll be good. And the pre-recording's not going to work, so I'll read it out. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, or city, township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Okay, this meeting is private, bearing false witness, misrepresentation, posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. One last time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting, a member or agent of any law enforcement agency of federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. And it looks like we're all clear. Great. Welcome, everybody. Hello, Glenn. Go for it.
Okay, so we're going to talk about bills of attainder. Everything they do, because they always do it, statutes, then it's a bill of attainder. It's a bill of pains and penalties. And we'll go through that. I have a PowerPoint presentation I've actually started working on, although I'm not finished with it yet. But so we'll just share that. So I'm not done with this, but so it's a work in progress, but it'll for everything we're going to talk about tonight, it'll be fine. So a bill of attainder means a legislative act, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. So legislative act, inflict punishment on them without a judicial trial. Bill of attainder, a special legislative act prescribing punishment without a trial for a specific person or group. They're prohibited by Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. A bill of pains and penalties. A bill of pains and penalties is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. And they're included in the bans under Article 1, Section 9, and Article 1, Section 10. Article 1, Section 9, Clause 3, no bill of attainder or ex post facto law shall be passed. Article 1, Section 10, Clause 1, no state shall pass any bill of attainder. So, first of all, the disclaimers. I'm not a liar. Well, I meant a lawyer. No, I meant a liar. You should never take my word for anything. You should always do your own research. I provide references to aid you in your research, but I don't know everything, and I'm open to any ideas. There's 4 types of people you'll meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people don't know the basic rights and freedoms, how can they know if or when or if their rights and freedoms are being infringed? Ain't that the truth? That's why they dumbed everybody down with the schools. Never forget the men who started this country were marijuana-growing, whiskey-drinking, tax-evading rebels who left their beds at night to shoot at the cops. All tyranny needs to gain a foothold is for people of good conscience to remain silent. I don't trust the government. I don't trust the I don't trust the medical pharmaceutical industrial complex. I don't trust the military industrial complex. I don't trust the mainstream media. I don't trust the bankster criminal cabal that owns the government, owns the medical pharmaceutical industrial complex, owns the military industrial complex, and owns the mainstream media. And if you call me a conspiracy theorist, I don't trust you. Government's not reason. It's not eloquence. It is force. Like fire, it's a dangerous servant and a fearful master. The greatest danger to American freedom is a government that ignores the Constitution. I think we're there, folks. But we can still hold our feet to the fire. Not all of them are crooks. There's certainly a bunch of them that are. When acting to enforce a statute and its subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent involved for the involved agency, but only in a ministerial and not a discretionary capacity. It is the accepted rule, not only of the state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. So think about it. The Constitution says that judges, Article 3 judges, are only hold office during good behavior, number one. And then one thing I was going to add in is stuff that's in the second amended counterclaim. And so then I'm going to share this Word document because this is stuff I'm going to put in there into this document. So this is my second amended counterclaim. The Constitution of the United States, dated September 17, 1787, is still in effect and has never been declared void, and is the oldest written constitution still in effect today, wherein Article 1, Section 1 says, all legislative powers herein granted shall be vested in the Congress of the United States, which shall consist of a Senate and a House of Representatives. Section 8, in Section 8, Clause 9, it states that Congress shall have power to constitute tribunals inferior to the Supreme Court. So the Constitution had not, prior to the statement in the Constitution being written, since this is Article 1, provided for a legislative Supreme Court. They were and could not, without any doubt, be referring to our one Supreme Court in and of the common law, which was already established and active in America and the United States of America. It is clear that the Constitution is now setting up another set of courts called legislative courts, and they refer to them as inferior courts, meaning inferior to the already existing common law courts. Our one Supreme Court, Article 1 of the Constitution, did then and there set up legislative courts inferior to common law courts, and as verified by Article 7 in the Articles of Amendment to the Constitution, wherein it guarantees that in suits of common law, no fact tried by a jury shall otherwise be re-examined in any court of the United States than according to the rules of the common law. The Supreme Court, talked about in Article 3, establishes a legislative inferior Supreme Court of the United States for the District of Columbia, which is established by an act to establish the judicial courts of the United States, approved September 24, 1789. And the Code of Law for the District of Columbia at 31 Stat 1189, March 3rd, 1901, establishes the Supreme Court of the District of Columbia, which is also known as the Supreme Court of the United States. And some of the judges, maybe all, I'm not sure, are on both. The chief judge is on both. And the nature of the jurisdiction is determined by the issues being presented. But the only true Article 3 court is our one Supreme Court, a common law court of the people, by the people, and for the people, and was in existence prior to the Constitution. So when the Constitution, if you think about it, when the Constitution is talking about a judge, they're talking about Article 3 judges. A real judge. And so this is Hale versus Henkel, 1906. His rights are such as existed by the law of the land, long antecedent to the organization of the states, and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. So law of the land means common law. When they use that phrase, they're talking about common law. This sets courts of common law separate and apart from legislative courts such as this court or the 97th District Court, otherwise being maritime court, that in any case tried in this court or the 97th District Court can be reexamined by action of appeal. This places this court in the 97th District Court as one of the inferior courts referred to in Article 1, Section 8 of the Constitution of the United States. Note the difference in a trial by jury in common law as to a trial with a jury in the legislated inferior courts. The judge in the inferior courts instructs the jury on what they will hear and decide upon and what they will not. There is no such provision in common law with trial with a jury. A common law trial by jury means the jury conducts the trial. The Northwest Ordinance of 13 July 1787, less than 3 months prior to the Constitution, so they had to know about it, which had never been altered by common consent or in any way or manner, and presently remains in force. The last words of the introduction or preamble of the Articles of the Ordinances state, the following articles shall be considered articles of compact between the original states and the people and states in said territory, and shall forever remain unalterable. And there's a quote of it. Was intended to be a part of the Articles of Confederation and forever unalterable, and all previous engagements entered into under Article 6, Clause 1 includes the Northwest Ordinance, which is in full force and effect in Texas. In this case, it's anywhere in the U.S. The compact agreement is a federal injunction, is forever unalterable either by legislative Congress or its legislative Supreme Court, or its other inferior courts, or the administration. It is protected by Article 4, Section 2, Clause 2 of the Constitution for the United States of America, which guarantees the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Article 2 of the Compact Agreement states, the inhabitants of said territory shall always be entitled to the writ of habeas corpus and a trial by jury and of judicial proceedings according to the course of the common law. The legislative law, statutory law, is in fact an extension of maritime law, and the 1946 Administrative Procedures Act, Title 5, United States Code, Section 559, at Sentence 2, requires administrative law to be in compliance with and in conformity to the Constitution of the United States of America, and the common law with all its prohibitions, restrictions, restraints, and limitations imposed by its enumerated Amendment 9, Bounds and Boundaries, Ninth Amendment. And that's really powerful. The Maritime Code, otherwise known as statutory law, being administered in legislative inferior courts. This court in the 97th District Court is evidenced by a maritime gold braid flag or the corporate seal in the courtroom. Also acknowledges that when brought inland beyond the high water mark or the first bridge of any navigable river, they must be brought into compliance and in conformity to the Constitution of the United States of America and subject to the common law. And this is 1 Stat 77, the Judiciary Act of 1792, saving to all suitors in all cases the right to a common law remedy, where the common law is competent to give it. And that's in 1 Stat 77. And in 36 Stat 116, third of all causes in admiralty maritime jurisdiction, saving to all suitors the right to common law remedy where the common law is competent to give it. Thus, meaning competent, common law is not extending in reverse of the high water mark, extending to sea or the jurisdiction of maritime law, or to exercise jurisdiction as stated in the Constitution under Article 1, Section 8, Clause 17, where it declares that the inferior tribunals will exercise exclusive legislation prescribed by Congress over such district, not exceeding 10 miles square, as may by session of particular states and the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the same shall be for the erection of ports, magazines, arsenals, dockyards, and other needful buildings. And clause 18, to make all laws which shall be necessary for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. Therefore, all legislative courts, this court, the 97th District Court in this case, only have jurisdiction in the District of Columbia under the Commerce Clause, which why they use zip codes, which are only in the District of Columbia, and commercial paper, Federal Reserve notes, forced loans, which are only for use in the District of Columbia. 12 U.S. Stat 411, Gold Reserve Act of 1934, located at 48 Stat 344. So the legislative, statutory, inferior courts themselves admitted the validity of the common law court in Strauss versus Strauss, which state every system of law known to civilized society generated from or had as its components one of three well-known systems: ethics, pagan, Stoic, or Christian. The common law draws its substance from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. Whereas we learn that the law of the land means common law, State versus Simmons, Justice O'Neill speaking for the court, Taylor versus Porter, Webster's definition of the law of the land, which is affirmed by Article 4, Clause 2, which declares that this Constitution shall be the supreme law of the land. Wiley versus Collins acknowledges the common law and the Holy Bible from which it came, which is the foundation of common law as our God-given constitutionally secured right. The 97th Congress declared the Holy Bible to be the Word of God by joint resolution, Public Law 97-280, 96 Stat 1211. So we're talking about, when the Constitution is talking about a judge, they're talking about an Article 3 judge, okay? And the reason it's a bill of attainder is because it's no Article 3 judge. This is the next, let me share, go back to the slide. Judge works for the state, prosecutor works for the state, police or witness works for the state. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, the only witness, also the police, all represent the same party, and since no corpus delicti, mens rea, or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. So there's not an Article 3 court, not an Article 3 judge. It's a bill of attainder. And I think I'll delete this slide. This one we can keep.
Why are you deleting it?
Sorry?
Why are you deleting it? Is it?
Well, it's not relevant to what we're talking about.
Okay, good.
This slide was this whole PowerPoint presentation was previously used for a common law presentation. And so I was talking about the different kinds of courts. So a lot of the stuff is going to be similar, but there'll be new stuff that I'll put in there too. So the important thing to understand is a court of general jurisdiction is presumed to be acting within its jurisdiction till the contrary is shown. And so... yeah, maybe I'll put it back. There we go. There are superior courts of general jurisdiction and there's inferior courts of limited jurisdiction. The superior courts of general jurisdiction, you see them all over. They might say the district court or the superior court. Okay, like in Arizona, they have superior courts, Pinal County Superior Court. So they'll actually say it's a superior.
Under? What a family.
Well, that's an inferior court of limited jurisdiction for sure. That's an inferior. That's actually D.C. Okay, family court. Matter of fact, if you read the Code of Law for the District of Columbia, it talks about divorces in there. Anyways, so it's definitely an inferior court. Even this court here is inferior. This is an inferior court of limited jurisdiction, and the statutes say what they are. But the thing you have to understand is the common law court trumps it all. So a superior court of general jurisdiction is presumed to be acting within its jurisdiction till the contrary is shown. So you have to show that, what I would do is I would object to this inferior court, even if it's a superior court of general jurisdiction, and I would go and get a common law court ruling is what I would do, and say this common law court ruling trumps your, and you have to recognize it. You'd have to twist their arm and get them to do it. But if you do a good job, there's a principle of law called exhausting your administrative remedies. And so if you don't exhaust your administrative remedies and you file a lawsuit against them, they'll dismiss it because you didn't exhaust your administrative remedies. So you have to exhaust your administrative remedies. And so you have to give them an opportunity to back off. So you got to bring up the issues that you're going to bring up on appeal and or the collateral attack. You see what I'm saying? And proceed that way. With my case, what happened is they held their kangaroo court, and the clerk didn't notify me that there was a decision. At least I didn't think it was a decision involving me because they just sent a letter saying that I could pay for it and that there had been a decision made. So I thought, well, it wasn't involving me, so then I don't need to worry about it. And then it turned out that it was. See, they were trying to sell their justice. Anyway, so I sued that clerk. And so now they're gonna be held accountable. You watch. We'll see. That's all I can say. We'll see. But so you got to exhaust your administrative remedies. You got to show you did everything you could before bringing it here. So what happened is that I missed out on my appeal because I didn't know that there was a case involving me, or that it was ruled against me, and that's why I brought it as a collateral attack, as a void judgment. Also, nothing shall be intended to be within the jurisdiction of an inferior court, but what is expressly so alleged, and if part of the cause arises within the inferior court and part thereof without it, the inferior court ought not to hold the plea. So again, with the federal courts, they're inferior too. They're all inferior. But the federal courts, it says in their statutes why you have to bring it, why you have to justification. Okay. In other words, if there's a federal act involved, if there's federally protected rights. I had a Arizona Attorney General bring a lawsuit into federal court that I filed in state court, brought it into federal court, and the argument was that I was alleging federally protected rights. And I was. So anyways, so this is more stuff here. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, which is always, it becomes a court of limited jurisdictions for the purpose of such a proceeding. So then think about it. They're always, any of those statutes are statutes, right? So they're always, they could start out as an Article 3 court, but then they automatically convert themselves into an inferior court of limited jurisdiction. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in exercise of such power is treating as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. It is familiar law that when special statutory authority and derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc, a court of inferior or limited jurisdiction. To be the statutes which would deprive a citizen of the rights of property, person, or property without a regular trial according to the course and usage of common law would not be the law of the land. A ministerial act is an act that a public officer is required to perform in a prescribed manner in obedience to the mandate of legal authority and without regard to his own judgment or opinion concerning such acts' propriety or impropriety when a given state of facts exists. Discretion, on the other hand, is the power conferred on public functionaries to act officially according to the dictates of their own judgment. So, remember, they were talking about a ministerial act, right? The word administrative is synonymous with the word executive. The word administrative connotes or pertains to administration, especially management, by managing or conducting or superintending the execution, application, or conduct of persons or things. Thus, administrative acts are those acts which are necessary to be done to carry out legislative policies and purposes already declared by the legislative body. In fact, it is common to use the two words in tandem. So again, the judge is not an Article 3 judge. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. There's actually a lot of federal cases that talk about that, and I put them in some of my paperwork that I filed into the federal court. Where there's no jurisdiction, there's no judge, the proceeding is as nothing. Such has been the law from the days of Marshal Saya. So anyways, they're required to give you a Republican form of government. Oh, and here's a good one. Let's start doing this here. Go back to the Word file. So even if this legislative inferior court could operate as an Article 3 court, this case is not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, because the wrongdoers are all in the District of Columbia as government employees. In 1861, the southern states walked out of Congress, and Congress ceased to have a quorum and conduct business. And on the 15th of April, 1861, at 12 Stat 1258, Lincoln ordered Congress to reconvene under executive authority. And 3 months later, on August 5th, 1861, at 12 Stat 292, while operating under executive authority, Congress approved an act to provide increased revenue from imports and to pay interest on the public debt and for other purposes, which precipitated all of this. That's the act that where they did land tax. And Congress has been operating under executive authority ever since. In 1871, under executive authority, Congress created a municipal corporation called United States for the government of the District of Columbia at 16 Stat 419 under Roman law. And now there are two national governments, one which Congress operates outside and independently of the Constitution for U.S. citizens and resident aliens under the Commerce Clause, Article 1, Section 8, Clause 3. And this is dissenting opinion, Justice Marshall Harlan of the U.S. Supreme Court. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress and outside and independently of that instrument. That U.S. attorney that showed up said they have immunity. Well, BS. I'm going to show them they don't have a shred of immunity. The Legislative Inferior Supreme Court ruled on a case that Lincoln failed to like, and Lincoln sent troops to the Legislative Inferior Supreme Court, which resulted in Rule 45. Rule 45 says all process of this court issues in the name of the President of the United States. Therefore, there is no separation of powers. Everything is under authority of Congress, operating under executive authority, and if this legislative inferior court is actually executive branch, and this legislative inferior court is actually the executive branch operating under Roman law, and all officers of this legislative inferior court are executive branch administrators. There is no common law offenses against the United States, only those acts which Congress has forbidden, with penalties for disobedience of its command or crimes. The state of Texas is a municipal corporation operating on executive authority that is a subsidiary of the United States corporation domiciled in the District of Columbia, operating under the Commerce Clause executive authority. Under Texas law, there is no act or omissions of crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. Congress passed the Code of Law for the District of Columbia at 31 Stat 1189, March 3, 1901, which is now known as United States Code, which all courts, federal and state, operate under. The Texas Department of Public Safety, the State Commission on Judicial Conduct, the Texas State Bar, the Texas Bar Foundation, the Board of Disciplinary Appeals, and the Bowie Independent School District are all subsidiary corporations to the State of Texas Corporation, which is a subsidiary of the 1871 corporation called United States, and all bar members perjure their oath at the drop of a hat by bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. So that's why I'm asking. So I'm doing a motion to get leave to file the second amended demand for relief. And I'm telling them that I got to justify why I want to bring the State Commission on Judicial Conduct in there, why I want to bring in Ken Paxton, why I want to bring in the Board of Disciplinary Appeals. I think that's the three. I think everybody else is in there. I'm just bringing those in there, and that's it. And it's because, well, the Board of Disciplinary Appeals, I filed 94 bar grievances against lawyers, and they all got dismissed, and saying that this is just an inquiry, and we're dismissing it. And so then I appealed every one of them. They went to the Board of Disciplinary Appeals, and the Board of Disciplinary dismissed them again. And so that's why they're being invited. And the State Commission on Judicial Conduct, I filed dozens of judicial complaints, and the State Commission on Judicial Conduct dismissed all of them, except for, well, no, it dismissed all of them, and they went and even dismissed 25 of them in one day. On the same day, they dismissed 25 of them. I got 25 of them in the mail on one day. So anyways, yeah. So that looks real good for them, eh? Anyways, this legislative inferior court is operating under the demandant's authority because Will Livingston, who ratified this Constitution for the United States of America on behalf of New Jersey, 18 December 1787, is the demandant's fourth great uncle, which means the demandant is posterity as found in the preamble, and the demandant is entitled to right of blood. And no civil law can destroy right of blood because all the laws of Congress and Texas are civil laws. And that's a maxim of law. Right of blood and kindred cannot be destroyed by any civil law. And this court is operating under power which is derived from the demandant as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. And that's found in Bouvier's Law Dictionary, 1856 edition. Therefore, the demandant failed to give any of these wrongdoers or their bar member handlers or this court any authority over the demandant, and John Marshall, Chief Judge of the Legislative Inferior Supreme Court of the United States, agreed. and said it's impossible for the demandant to confer a sovereignty which will extend over him. And that is, consequently, the people of a single state cannot confer a sovereignty which will extend over them. And the demandant is exempt from these county of Montag fees, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority which makes the law on which the right depends. And the demandant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, which is the supreme law of the land, anything in the constitutional laws of any state to the contrary notwithstanding. And we, the people, fail to be U.S. citizens because U.S. citizens failed to exist when the Constitution was written. The term citizen of the United States must be understood to intend those who were citizens of a state as such after the Union had commenced, and the several states had assumed their sovereignties. Before this period, there was no citizen of the United States. And there's actually two classes of citizens. So one of the things that I got here recently, and this I think is interesting, I was thinking about including this. Where is it? This is one of the handy things about being on this group. I've got a couple of groups on Google and on Freelist. And this is one of the handy things. This is there's this guy on this group, Veritas Ghost, that puts out lots of really good court citations and stuff. There we go. So this is the court citation. There's a bunch of them in this one. Corporations are not authorized to bring suits under the Privileged Immunities Clause because it protects citizens, and the Supreme Court held that corporations are not citizens within the meaning of the clause. So this is important. I've been thinking about putting this in there. And then there's this another one. To determine whether an activity is a right worthy of the protection of the Privileged Immunity Clause, it must be sufficiently basic to the livelihood of the nation that it constitutes a fundamental right. Included among these rights are the rights to own and dispose of property, the right to access to the courts of the state, and the right to pursue a common calling within the state. From the earliest interpretation of the Privileged Immunities Clause has been established that the right to the ownership of privately held property is a fundamental right protected by the provision. The states may not interfere with the right of a citizen of one state to take hold of and dispose of property, either real or personal. So I've been thinking that this would be a good one to put in there. This is one that this Veritas Ghost put out there recently. So this looks pretty juicy. I need to, it just makes it longer. That's my only problem. I've already got it too long. Anyways, so does anybody have any questions? I'll open the floor up to questions. So it's all bills of attainder. You got to understand it's non-judicial proceedings. Everything that goes on nowadays is, well, it's a bill of pains and penalties, actually, because a bill of attainder is a capital punishment. So it's a bill of pains and penalties. But the bottom line is it's a non-judicial proceeding. It's not an Article 3 judge. There is no such thing as an Article 3 judge unless it's a common law court. These judges in the federal courts, the so-called Article 3 judges, I told them that they're not an Article 3 court, and so therefore they can't be Article 3 judges. Matter of fact, let's share that again. And that is found in Puerto Rico. United States District Court is not a true United States court established under the Constitution, Article 3. So if the court's not Article 3, then neither are the judges to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 of making all needful rules and regulations respecting the territory belonging to the United States. So Texas's territory belongs to the United States too. Think about it. All United States district courts.
Yeah, didn't you hear that Trudeau's the 51st governor for the United States? That's what he announced.
Where did you get that from?
That's what he announced. Or there was talk of that when he had dinner with Trump at in Florida in Largo.
Mar-a-Lago?
However, yeah. That.
Well,
last
that's interesting.
shooting place. I don't know. What do we call it?
That wouldn't surprise me. That wouldn't surprise me at all. I think what's going to happen, there's going to be a lot of chaos over the next 6 months. And what I'm hearing is that Trump's not going to take office in January. It's going to be in March. Now, the interesting thing is that Roosevelt, all the presidents up to and including Roosevelt, took office on March 5th. And Roosevelt declared the United States bankrupt the next day. And after that, the inaugurations were in January. Let's find that. There we go. Are you guys seeing that? Yes, you are. Let's make it bigger. Okay, there we go. March 9th. So March 9th, it was March 9th. Let's March 9th, 1933. So he took office, I think it was the 5th, but I'm not positive. I think it's the 5th. So it took 4 days then. Since March 9th, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways control the lives of all American citizens. The majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's taken from NRE U.S. Senate Report number 93-549, dated November 19th, 1973. You think anything's changed? Absolutely not. And there's also, this is congressional record. It's an established fact. The United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5th, 1933. Joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental officers and departments, and is further evidence that the United States federal government exists today in name only. United States Congressional Record, March 17, 1993, volume 33. So,
Then I got a quick question, if I can.
what's that?
Well, remember when you were back talking about what was it? Hinkle and I believe it was Hale versus Hinkle.
Yep.
Back in that area, and you were talking about the Northwest Ordinance, was it?
Right.
And coming out right before the Constitution. So that's still in effect, and it's not to be changed or altered, right?
Right.
Isn't that how it goes? Or
yeah, that's exactly how it goes.
so none of that changed in 1933, or the Emergencies Act or whatever they do.
Well, no, what happened, I agree. What happened is the government's bankrupt. And now what you have to do is you got to bring that stuff up because, they're now owned and operated. They have a duty to their owners. And unless you can show that their authority comes, like I tell them that their authority comes from me, because Will Livingston's my fourth great uncle, and he ratified the Constitution for New Jersey, and they can't supersede that. You see what I'm saying?
Yes, sir. Yep. No, I agree.
So,
I caught that. I was like, I thought that was interesting. I didn't catch that was right before, a couple of days before the Constitution.
Right. Right. So they still have to follow the law, but they sit there and they first of all, they give you an admiralty court or a maritime court, not an admiralty court, a maritime court. And if you just accept it, then you're going to get railroaded. You have to stand up to it and say you don't have jurisdiction. I object to your maritime proceeding. And especially if you can get convene a common law court with your peers and get a ruling on that, then they have to recognize it. That makes them, especially you got to show them that they have to recognize it. You see what I'm saying?
Yeah, no, that sounds good. Yeah. I mean, I do, I everything I've had to deal with, I've done only strictly equity without any laws or statutes or cases or anything, just the equitable parts of them. But it was never anything important or serious. You know what I mean? But I could totally relate to that, helping somebody and anyone really. I don't think you have to do anything, change no status or nothing.
Yeah, you have to bring up the issue. They'll try and railroad you, and you have to stand up to them and say, sorry, you have to follow this. And if you do it in the right way, you bring up the right issues. First of all, you have to be careful not to argue the case, the merits, you got to start off arguing jurisdiction right off the bat. If you start arguing, it's like any contract, right? If you argue the terms of the contract, you're admitting the contract. So you cannot argue the terms. You got to cut to the chase. You can argue the terms. Where's your authority to even be talking to me? You see what I'm saying?
Yeah, I see how you're doing it. Like I said, I do it strictly equity. It's a little different as far as we don't act. we don't argue the jurisdiction, facts, venue, any of that. We're just there to settle the matter, and I mean, there's a lot to it, and there's a lot of knowledge to learn about it, but I can see what you're saying. You know what I mean? If I didn't learn what I know now, but with equity, yeah, I'd be all about what you're talking about,
If you're going to argue equity,
I could always use fall back on that one way or the other if I needed to, but
if
I haven't needed to.
yeah, it's really hard to hear you. But at any rate, if you're going to argue equity, you have to have clean hands. If you have participated, then you don't have clean hands. Anyways, anybody else have anything?
Glenn, I hope you didn't get me wrong. I said I totally understand your the way you're doing it, and I caught that. But yeah, no, I said I do equity, and I haven't handled anything like major or of any real major substance or serious cases. I just had personal little credit cards and whatnot, and I don't. But when you just said argue equity, yeah, no, I'm talking about not arguing anything. You know what I mean? And I don't bring up equity. It's just the way you do your paperwork and you come and the word you use. You know what I mean? And
Well, everything's about the words, that's for
judge,
sure.
the judge, yeah, the judge understands the words you're using, and with a courtroom full of people, you can get what you need done if you bring equity properly. Yeah, but I like what you had to share.
Well, they're not. None of them are Article 3 judges, and so if that's why I would just be bringing it into a common law court and get it out of there, because there's no justice that goes on in those courts. Anyways, is that about it? I think we've been going for over an hour. I guess that's probably about it then, eh?
No, I want to know how they keep giving themselves all this immunity, and they keep letting themselves off the hook. Like, how do we get them?
Well, you got to pierce their immunity. All you have to do is show that they're not operating in their official capacity, and that's actually quite easy. And once you do that, then they're operating in their private capacity. Remember the same stuff that we just went over in Article 3 of the Constitution. It says that all judges shall hold office during good behavior. And if they're not in good behavior, then they're not a judge. And so, that's the argument. But you got to understand that. Most people don't have a clue about that. Most people are brain dead idiots, and they just grind them through the system and fleece them. And that's the way they do business. So if you anybody that goes in there and knows what's going on, it shouldn't be that difficult to defeat it all. But they don't like to. They're taught classes on how to do that stuff. I got to tell you for sure. And so there's a guy that I met that I know that lives in. I think he lives in Nevada. He was telling me that a friend of his was appointed a judge, had won an election to be a judge in Nevada. And he had to go for like a 2-week training class. He was all excited. And he went to this. It was in Laughlin, Nevada. So he went for this 2-week training class, and he came back, and a friend of mine said that he was all dejected, he said, because all they did is taught him how to get people into a contract. That's what they did. So it's, they don't teach him how to do justice. They teach him how to be unjust. He was really discouraged after that.
Warehouse everybody, eh?
Yeah,
Get them in
exactly.
to fill up the prisons, which are
Yeah.
over
Yeah.
full already.
Yeah, right. Populate the prisons.
So it took him all the way to being a judge or being almost appointed into that position for him to realize what the frig was going on.
Well, he won an election. He ran for election. And so then he was all excited and thought that this was going to be a great privilege and honor.
Yeah.
And
yeah, he's going to pop on. He was actually elected and not selected. That's
well, most actually in the states, all judges are elected, except for the federal judges. Federal judges are all appointed.
Okay, here, well, they're all selected, right? So,
yeah, no doubt. But in Canada, it's the same thing. Once you understand what's going on, it all works the same way. So the argument is that he's not a judge. Okay, under the Act, okay, the Constitution Act, and I don't know what it's called in Canada. I know that there's certain separation of powers, and there's certain, and so all you do is you say he's not a judge under the Act. This isn't a judge, and it's a bill of attainder, and there's Supreme Court cases in Canada that talk about bills of attainder too.
Mm-hmm. Yeah, there definitely is. Can you post that group that you were saying had real-time postings of cases that you would refer to for some of these new items that you're putting in this case?
Okay, well, there it is right there.
Okay, you got that.
It's called Administrating Your Public Servants. That's my group. There's two of them. There's one called Administrating Your Public Servants at googlegroups.com, and there's another one called Administrating Your Public Servants at freelist.org. So you can go there and add yourself. I cannot add anybody because Google's not letting me have access to the that. But you can go and add yourself, and it'll be no problem. And the freelist.org, you got to do the same thing. And then if you decide you want off the group, you get a lot of emails. If you want off the group, then you got to get yourself off. I can actually off the freelist group, but it's a major pain in the butt. And it's you get yourself on, you need to get yourself off. Actually, at the bottom of the emails, if you go down to the bottom, right here, let's see here.
You can turn off chat emails or something, or reply.
You can turn off to unsubscribe. To unsubscribe to this group, you just click on that link. And the same thing applies on the free list group. There's a link where you can unsubscribe. Also, when you set yourself up, you can set it up to, instead of getting an email every time, you can get an abridgment. And an abridgment is one email every day that'll give you a little bit about the email and then a link if you want to look at the whole thing. So if it's not something you're interested in, you just go to the next one. So it's a lot less emails.
I like that option. You wrote that into the code yourself?
Sorry?
You wrote that option into the code yourself?
No, that's available on Google.
Nice. Okay, I didn't know, because when I signed up, I was getting 49 emails a day, and that was hard to, delete that many each day. So
I know. I delete hundreds of emails every day. But it's my group, so I need to, if there's people that are a problem, I need to be aware of it because I can deal with it. but so you can get, there's actually two ways. You can get an abridgment, or you can get one email. You can get them all on one email. It'll be like a big long chain, and or an abridgment, or you can get no emails. You can take yourself where you still be on the group. You just won't get any emails. It's up to you.
It's nice to hear Google acting in a correct capacity. Thank you.
Yep. So you can this guy here, Veritas Ghost, he puts out a lot of court cases. So I always look at his because I want to see what court cases I might want to have. And like this one here, I saved it because there was some court cases that were relevant to what I'm doing right now. But what happens is if you go here, like I've got this administration, this label called administration, and I save, look at all of his emails that I saved there, because but there's other people's emails I saved there. If there's something interesting, I'll save it there, and then I'll have it. I can go back to it if I want, and so I keep them, some of them that are interesting, and that I want to be able to refer back to in the future.
Yeah, that's how you stay in the know. Very nice. Nicely organized.
Yeah, well, and then I got about 10 email addresses. Google's blocking me from one of them, but I still have, let me show you. I do it in Firefox. Firefox
I only have 2.
I've got, these are all my Gmail addresses. Here, let me show you. I'll share it. These are all Gmail addresses right here. Republic of Texas, one Winfern. This is one I do for eBay. I have eBay just about. This one here is my Coinbase. AES is American Engineering Services. Winfern, Engineer Win. This one Google is blocking me from, but I've also got Living Soul for You and 3 Living Soul for You, and there's actually more, but I don't go to them very often, so I just basically quit using them. But this is all in Firefox, and so I've got quite a few email addresses that. And what you do is you can set it up so, like with this is my Coinbase one. It'll open up as a separate window, and so I can actually be checking all those emails at the same time. And so it's amazing what you can do if you set it up right.
10 emails. I'm jealous. No, that's a lot. That must be part of your engineer training, because that would be a lot for me to manage and keep active.
Well, what happens is you're right. It is a lot. I've had a lot of them go inactive. What happens is I use them for emails, like I've got, like on the Google one that they won't let me have access to. I've got probably a couple thousand email addresses there that I send out emails to. And so if I want to send something out to a bunch of people, and there are people that I've been in touch with forever. And so, I mean, I just, people that, like even this one here, let me share that one. This one here has a lot of emails. Here's my contacts. So I've got 36, 176 in Alberta, 43 in BC, Canada 114, Nova Scotia 4, Ontario 35, Parliament. I've got a bunch of emails for people in Parliament in Canada too. So that one's got probably about 1,000 emails. So if I want to send, this is mostly, I concentrate all my emails that I know are to Canada. I keep them on this profile. And then the other one that they're blocking me from are U.S. emails. And then I've got another email address that's mostly international, that's overseas, like Australia. And so if I want to send emails to Australia, then or to overseas, to France, to England, that's on another email address that I use, and that way I can send out a bunch of emails. And I do it from different addresses, from different profiles, because Google blocks you if you send too many emails out. And what happens is, like, if I can send out 500. It used to be I could send out 500 twice a day. But Google's is now I send out 500 if I do it, if I do it more than once a day, they'll bounce them. They'll actually bounce. Matter of fact, I need to sue Google because I've been, it's not just about the bouncing the emails. It's about them forcing me to log in and all the rest of that crap and give a phone number. It's none of their business what my phone number is. And so, anyways, so that's all part of, they want to be sued. So I'm going to have to sue them. They're already in the middle of a lawsuit with the Federal Department of Justice. Anyways, I suppose that's about it. Is there anything else we want to talk about today?
Well, thanks for showing us how you control the cabal. I would have never guessed 10 emails. Oh, well done. Well done.
I do. This is my website. I have another little thing here. My webmaster. I've got a webmaster. Let me show you my website. This is my subscriptions. My webmaster set this up for me. This is people that subscribe to my videos, my exclusive videos. These are the YouTube videos, okay? Now, I don't have anywhere near the control over the how-to videos, but you can still subscribe. I don't really tell people about it, but people still come and want to subscribe to this, and I don't turn them away. And so these are my subscriptions. These are people that have. Sometimes the Y here means it's been validated. In other words, they'll validate it. In other words, the website will send them a link, and they'll click on the link, which means that it is a real email address. You see what I'm saying? Anyways, these are subscriptions where people send me, $90 for a year's access to my exclusive videos, and there's probably, I think there's about 1,000 emails here. There's a bunch of them since right from the beginning. So let's go down to, this is when I first started doing this was 2018. And sorry?
I'm on that list. That's where I'm on that list.
You might be. So right now, I've got about $2,700 worth of subscriptions every year. That's the annual, the open subscriptions. That'll be in the last year, and it looks like there's the total value of $21,000 over since 2018 of subscriptions. So it's a little bit of money. It's not like a lot, but it's better than a poke an eye at the bird stick. You know what I mean?
I think it's awesome.
So my webmaster, he lives in Canada. He lives in Edmonton, and he's a brilliant guy when it comes to websites and stuff like that.
Well, keep them in your side, because good web builders are hard to find, because they can be very expensive.
Yeah, well, it's I had built the website already myself, but he went and made a bunch of changes to it, but he's my webmaster, and I pay him like about $600 a year to take care of it. And I want to send them a nice bonus when my cryptos come in. I'm going to make sure and take care of them really well. But see what he set up here is I can actually send an email out. See right here, I can send out an email to all these people, and it'll send out emails to everybody on this list, all of the ones that are verified. And it got to the point that if it got over 500, it'll start bouncing them because of the system, the way the system is. So what it does is it sends them out in batches now. He modified it. He had to dick with it to get it so that it would work. But he modified it and so that it sends them out in batches. And that way, I think there's about 1,500 email addresses here. So if I want to send out, the only drawback is that it's text. I cannot send links or graphics or anything like that. It's all just text. And so that's the only drawback. But it'll go out to all those people that I've been in contact with. Have you gotten any, Lori?
I think you have my old email address. Because no, I didn't. I'm in the Yahoo group, the Sovereignty International Yahoo group. And that's where I get.
Okay. Well, this is my subscription website anyways. Looks like I have a subscription expiring in 2 days. No, today. This one's expiring today. Anyways, so it brings in some money. And then people contact me and need some help, and and then stuff that I do around here, every little bit helps. And I got some crypto investments. You see what's happening with cryptos, eh?
Tell us your side, because there's always new news about that.
Well, actually, what I should do is I'll show you the video. There's a video that I got from a guy by the name of Max Wright. Right here. Are you guys seeing this? Nope, you're not. This guy, Max Wright, is a guy from Australia. He lives here. I've been following him for probably about 10 years. And I first, run across him when he's a Bitcoin guy. Anyways, this is a video. This guy here, this is YouTube. This guy here. So I don't know if anybody recognizes this guy.
But I recognize Vaughn.
Juan? You recognize Juan?
Mm-hmm.
Really? That's interesting. Well, he's been on Max's channel, but Max Wright is the guy that I've been following, and Max has Juan on there. This Juan guy is really brilliant about trading, about charting. He uses the charts. Anyways, listen to what he says here.
Darn, we're not hearing it.
You gotta click on the audio, Glenn.
Really? How do I get the audio again? I know I had to do that before.
Click the share screen button to the left of the mute button, and then select audio.
Got it. Okay, I'll start it. I'll back it up a little bit.
Such, I see you actually. So the last time we chatted, it was a week before the election. Bitcoin price was hovering just south of $70,000, I believe. and you told me that November 5th, the day of the election, was going to be one of your cycle lows, and you were predicting very exciting price action after that. Well, Nostradamus, you absolutely nailed it. November 5th, the price absolutely explodes. And within a few days, we've gone from 70,000 to 90,000. And it just is a big rip up. Do you want to take a moment to take your victory dance?
Okay, well, I can put a link to this video in the chat if you want. I would highly recommend you watching this because this guy, he's saying there's going to be another bottom on the yesterday. And if you notice that yesterday, Bitcoin went through 100,000. And so he said there's going to be a bottom yesterday, and Bitcoin's now over 100,000. And he said that Bitcoin is going to peak out at around 150,000 sometime between February the 5th and March the 5th. And then that's going to be a top, a recent top. And so that means it's going to go down. He doesn't know how far, but anyways, so this is an opportunity, and I'll tell you what I'm planning on doing is I have a bunch of Ripple, and it was at 50 cents before the election, and now it's at $2.50. So I've made 500% on my money, and then I've got a bunch of other ones too, some AMP, and I've made pretty good money on that stuff. And I'm expecting that what I'm going to do is I'll turn it all into Tether around the 5th of February through the 5th of March. When it gets up around 140,000, I'm going to be dumping it and turn it into Tether. Tether's a stable coin. And I'm going to put it on Coinbase and have an open transaction for Ripple at 20 cents because I'm expecting that there'll be a crash in April. And I'm just going to sit there and wait. And so I would highly recommend you watch this video and get a feel for what, because this guy's pretty sharp anyways, and you might want to subscribe to Mac's channel. Let me put this in the chat. I think I might have done that already, but.
What if Bitcoin blows past 150 to 500 or a million?
Well, it's eventually gonna, for sure. Matter of fact, it's going to go up. You know, he's saying in here that he thinks about maybe 300,000 next year. But the bottom line is a Bitcoin always goes through these cycles. So if you play the cycle, you know what happened is in 2017, I rode Bitcoin. I had like, I don't know, 5,000 or 6,000, and I rode it up to 50,000. I had 60,000, and then I rode it all the way down. So I learned from that. I'll tell you, I ain't doing that no more. So you sell high, you buy low, you sell high, you take your profit, you have your targets. You just don't get caught up in it, and it's going to come back. Don't worry about it. Take your profit, and you know. But I'm expecting this next year to be really, because of Trump and all the shit that's going on right now. I'm expecting this next year just to be just total chaos. And so there's going to be major opportunities. There's lifetime opportunities, I think, are going to happen this coming year. I think that what's going to happen is Cliff High's talking about it, where they're going to offer. He said they're going to make 3 offers. And he said they've already made one offer. Cliff High is saying that if the BRICS dump our dollar, then he's going to put 100% tariffs on them, right? Because he wants our dollar to be the central bank, or no, the world reserve currency. And Cliff High saying we don't want any world currency, world reserve currency. And so I think he's right, because it should be gold or silver coin. And so anyways, so Cliff High said there's going to be 3 offers. The first one was this one, and then about a month later there's going to be another one, and then another one in, like, you know, January sometime or February. And he said, so I think what's going to happen, there's a guy that gets these dreams, and he said that they're going to crash it in April. And so that would all fit in perfectly, because the people that are behind all of this are psychopaths, and they don't care who they hurt. Matter of fact, if they can't have it, they'll burn it down. And so I think what's going to happen is they're going to try and destroy it and just burn it down. And that'll be in April. And so that'll be like major opportunity. You'll be able to buy in. The guy that had that dream said he saw Bitcoin at $1,200, right? So a Bitcoin's at 150,000. Now you can buy it back for 10 cents on the dollar. He saw Ripple at 20 cents. Well, right now Ripple's at 250, and I think it's going to go up to around 4 or 450. And then I'll dump it. And so then I'll be able to buy it back at 5 cents on the dollar. And then it'll take off like a bat out of hell again next year. So, I mean, there's like major swings. This is where you make your money, folks, is on these big swings is where you make your money. But you got to be cold. You got to just have your targets and stick to them and take your profit and don't get caught up in it. And, so that's all I can say. I think I'm going to be, probably, who knows? I guess we'll see. But I've always known that at some point I'm going to have more money than I'd ever know what to do with. And I think that we're so close to that, I can just like feel it in my bones, I'm telling you. And so we'll see. That's all I can say. I would highly recommend you watch this because this guy's pretty interesting. And watch Cliff High's stuff. Cliff High uploaded 3 videos today. That he has a Substack. I go to substackcliffhigh.com or cliffhigh@substack.com or something like that. He's got a Substack, and watch his videos. He's pretty interesting. He's got some ideas that you don't necessarily agree with, but it's food for thought. You just don't know. I just put it in the back of my mind, and but he's got those data sets. He said that like the Joe Rogan interview. He said that he picked up that Joe Rogan interview in 2008 in his data sets, but he didn't know who Joe Rogan was going to interview. And he said that when he finally came out that Joe Rogan was going to interview Trump, he knew it was 39 days to chaos, which was yesterday, where the chaos starts. Now, I haven't really seen that much big escalation and chaos, but that doesn't mean it's not going to be. I guess we'll see. To melee, he calls it melee, which is Cliff High is a guy that his dad was the only guy that got a field commission in the Korean War. Now, if you understand what a field commission is where an enlisted guy that they were in a battle in the Korean War, and this guy, his dad, saw that they were going to get overrun and killed if they didn't get to the top of that hill over there. And so he started heading for the top of the hill. And he looked behind him and everybody was following him. So he was a natural leader. He got a field commission and he wound up going to the War College in Leavenworth, Kansas, where they teach you about warfare. And so Cliff High went with him. And so he was in college all day and Cliff High was sitting at home with nothing to do. So Cliff High had all these textbooks. He was reading his textbooks. So he learned about warfare. And so melee is when, he says a good example of a melee is when Custer's last stand, right? Usually what happens is you'll have a general up on a hill and he'll be seeing all of the enemy and everybody, all the troop movements and stuff. And he'll be issuing orders to his lieutenants and commanders and telling them to move these troops over here and move these troops over there and that kind of stuff. And what happened is General Custer got killed early in the battle. So there was no leadership and it was just total chaos and the Indians killed them all. And that's how they did it. If Custer would have not been killed, it could have been an entirely different outcome. Anyways, so that's a melee. It's a melee for General Custer and his troops, but the Indians, they knew what they were doing, so it wasn't for them. It's total chaos. And so he says that he figures that the melee is the deep state collapsing, and so he says he expects bank failures, he expects all sorts of stuff to be happening. So it's going to be total chaos, and we need to be ready for it. But it's major opportunity, major opportunity. And so if you're ready for it, and so, you know, that's all I can say. Anyways, if that's about it, I suppose I'm going to sign off.
Well, thank you so much for being so generous with your time tonight. You know, I appreciate it, and I always enjoy hearing you, getting updated on all your cases. Thank you so much. I hope you come back next week. Keep us updated, and I don't know if anybody has anything else to say. I'll let you go because I know you've been on here for, you've given us, you've been way more generous. So I'll let somebody come forward, and then you have a good evening, a good weekend, and please check your DM. I want to know if you can accept money transfer through this RIA moneytransfer.ca system that I found, which will eliminate all of these courier things. So check on that, please. Is there anybody else who wants to say anything to Glenn in closing, and then we can, you know, close off the chat for his time tonight?
Mind if I have a quick one? That was an
Sure,
amazing wrap up. But when that bill of attainder is a death sentence, did you mean that literally or metaphorically, or both?
Well, bill of attainder,
something like a death sentence.
It is. It is. A bill of pains and penalties is something less than a death sentence. A bill of attainder is a death sentence. So they give you a non-judicial proceeding and sentence you to death. If it's a bill of pains and penalties, they give you a non-judicial proceeding and sentence you to anything but death.
Okay, thank you.
So that was literal.
Almost literal.
Yep. All right. Well, Lori, send me an email. Send me a link to that, and I'll check it out from my end.
Okay, definitely I will. It's linked up there, but I'll send it through the email too. So you have a good night, and thank you very much. I'll send you the recording.
All right, sounds good.
Tomorrow.
And we'll see you same time, same place, same channel next week.
Please, please. Okay, cheers with beers. Well, you know, whatever you're drinking.
Tea, iced tea.
Perfect. Good night, Glenn.
All right, take care. See ya.